Mr. Knox, thank you.
My Lords, just to pick up on a point raised before lunch, and that was the decision of Bain, which I referred to, and so I think Lord Burrows asked me whether there was any had any case or academic article considered the interrelationship of section 120 of the Code as against section 66 of the Evidence Act. And I mentioned the case of Bain. That is in the bundle at Authorities Bundle, Volume 1, Tab 14. Judgment begins at the judgment of Lord Hamblin at 44116. The relevant pages are 4143 to 4145. They just mention in that judgment, because it wasn't, so to speak, central to decide exactly what the relationship was between the various provisions, Lord Hamblin simply sets them out. He does note that it's not quite clear what section 120 subsection 6 is supposed to be doing, but he also notes that the Court of Appeal in this case, in Stubbs, had taken it that the overriding power in section 120 subsection 2 applies not only if you want to get your report in under subsection 1, but it also applies to the provision you see in subsection 6. And my Lord, I don't dissent from that. I don't say that I can just rely on section 126 and say, sorry, section 120 subsection 6 and say it doesn't matter, even if it's completely contrary to the interests of justice to do so. I don't think I want to be pushed into that corner. And I think I might be in difficulties on the fair trial point if I were to, if it was unfair to do so in any circumstances. So that's the best I can do. My Lords, I'm conscious of the time. I want to take you, I think, just to the case of Grant, because it is really plumb on many of the points which I seek to make. And that is at volume 2 of the Authorities Bundle, at tab 35, at page 4560, 4560. And this was a decision from Jamaica. And the issue in this case was the admissibility and evidence of two written statements. They weren't talking about analysts, but the question arose whether or not the written statements, one of which was admitted, the other was not, whether those statements were, the admission of those, or the one of the statements, was contrary to the equivalent provision in the Jamaican constitution, on the footing that by admitting this written statement in without cross-examination, there would be a breach of the equivalent cross-examination provision. And you can deal with, you can see the relevant Jamaican section at page 4570. I think I'm right in saying that it may be word for word identical, but if it's not, there doesn't appear to be any material difference. I haven't checked that, but it looks word for word identical. Paragraph D, 4570 at the top of the page is where it's recited.
Yes.
Now, in this, what the board did in this, it then went on to analyse. You see counsel for the appellant's arguments at paragraph 13, and essentially he runs the argument that this should be treated like the Sixth Amendment in the United States, as effectively an absolute provision. But he refers also to the other equivalent provisions in the European Convention. And then you can pick it up on page 4571, 14, paragraph 14. The board wouldn't wish to question the validity, general validity of the principle for which the appellant argues, namely, you should always get the witness along. The evidence of a witness given orally in person, in court on oath or affirmation, so he may be cross-examined, and his demeanour under interrogation evaluated by the tribunal fact, has always been regarded as the best evidence and should continue to be so regarded. Any departure from that practice must be justified, but for a number of reasons, in large measure those advanced from the Attorney General and accepted by the Court of Appeal, the board cannot conclude that section 31D of the Evidence Act, which allows written evidence herein, hearsay, is inconsistent with section 20, subsection 6D. One can in particular then go on to paragraph 15 makes the point that the constitutionality of a provision is presumed, and it's quite difficult to get around that. Then paragraph 6D, my lord, is really the important paragraph, where towards the end of the paragraph, you can see by letter F, it would, in the opinion of the board, be wrong to construe sections 13 and 26D of the Constitution as guaranteeing that there would not, without a constitutional amendment, be any further statutory exception to the hearsay rule applicable in criminal proceedings. But it is, of course, clear that any new exception must not compromise the fairness of the proceedings, which section 20 is designed to protect. And I say, likewise here, there's nothing wrong with the Evidence Act providing for the report, the analyst's report to be provided in evidence, subject to the overriding justice point. And then paragraph 17, the board goes on, 17.1, the board goes on to consider Strasbourg jurisprudence and Article 6.3d of the Convention on Human Rights, and notes, I think, at subparagraph 1 on 4572, that the overriding question is simply the fairness of the proceedings, rather than the apparent absolute wording of Article 6.3d. And then likewise in subparagraph 2 on 4572, just as section 13 of the Constitution recognises that individual rights cannot be enjoyed without regard to the rights of others, so the Strasbourg Court has recognised the need for fair balance between the general interests of the community and the personal rights of the individual, and has described the search for the balances inherent in the whole Constitution, Convention. My lords, I say likewise here, that's exactly the point the judge was on when he admitted this evidence, saying, well, there is a public interest in having this evidence in, which I ought to take into account. I submit this is an entirely justified way of looking at things. And then subparagraph 3 at the foot of the page, 4572, that while therefore the Strasbourg jurisprudence very strongly favours the calling of live witnesses available for cross-examination by the defence, the focus of its inquiry in any given case is not on whether there has been a deviation from the strict letter of Article 6.3, but on whether any deviation there may have been has operated unfairly to the defendant in the context of the proceedings as a whole. This calls for consideration of the extent to which the legitimate interests of the defendant have been safeguarded. And my lords, then further points are then made. And then over the page, 4573, paragraph 20, the contrast which I mentioned before lunch. Sixthly, the right to confrontation expressed in the Sixth Amendment to the US Constitution for all its interest to legal antiquarians is not matched by any corresponding requirement in English law, and a reference made to Lord Rogers' judgment in Camberwell Green Youth. And then, my lords, section 20, paragraph 21, Lord Bingham goes on to say why in the Jamaica evidence provision, the evidence provision meets the requirements of the Constitution. And you'll note, my lord, that in section subpara 1, section 31D, the Jamaican provision on general hearsay evidence, sets out with clarity the conditions to be met before the application may be made. Relevant to this case is the requirement that all reasonable steps would have been taken to secure the attendance of the witness. So I would accept that in general terms, that section 120 would be, it might be said, to lack a necessary safeguard, were it the case that it was talking simply about hearsay statements generally. But for the reasons I've given, the position of an analyst, it is perfectly legitimate for the legislature to provide for a different provision for the analyst in general, subject to a fairness provision. And I submit that makes perfect sense. And indeed, I say that the facts of this case are rather a good example of it, because here, on the face of it, you had a surrogate expert who could come along and answer all the questions which the original expert could have answered, and the defence did not give any adequate reason for saying that he couldn't. So I submit this is a rather good example of why you have a slightly different regime for analysts' evidence. My lord, the only other passage which I should draw your attention to, in fairness to the appellants, is on page 4574, subparagraph 4. Lord Bingham points out that this does require directions. If you allow hearsay statements in, you can pick it up at subparagraph 4 at about B, halfway down B. But the direction should not stop there. The judge should point out the potential risk of relying on, and so forth. So the judge, when he admits hearsay statements in, must give appropriate directions. I'll come on to the directions given in relation to the expert in this case. My lords, this interpretation, I should say, of course, the case of Horncastle, in the Horncastle a few years later, the Court of Appeal and the Supreme Court gave a very detailed consideration to Article 6(3) subpara D, because the European Court of Human Rights had in the meantime come up with an interpretation that said that you should always exclude, effectively, hearsay evidence if it was either the sole or decisive piece of evidence in the case. And that was in the case from England. And the Supreme Court didn't, neither the Court of Appeal nor the Supreme Court agreed with that. And they basically said, no, the test under Article 6(3)(d) is, in fact, as set out by Lord Bingham in Grant. And if I can just give you the reference for that, it's at 4768 in the authorities bundle. I think it's at tab 37. 4768 at para 65. And my lords, the Supreme Court expressly draws the distinction between that position under the ECHR and the US provision in in the Sixth Amendment. And they do that in paragraph 43 at 4762. So, my lords, I submit as a matter of a law that the judge did nothing wrong in applying the test he did. He looked at the overall interest of justice. It was one factor that Mr. Higgs was not going to be able to be cross-examined himself, but there was no sufficient reason provided to him for excluding what was obviously, and I accept this, obviously was important material. My lords, can I just make just a few quick points on, and they're in our written case, on the question of prejudice. I submit that even if the judge went wrong in law in admitting the whole of Higgs's report, then through Thompson, then there was still no unfairness that's resulted and no prejudice. And the reason I say that is as follows. First, there is no doubt that in Stubbs's case, the gun he is said to have been in possession of at the scene was a .45 auto, and equally no doubt that one of the casings found at the scene immediately after the event was a .45 casing. And importantly, and this really is the point which matters, as the point I've made before, is the casing was found just outside the club, which is where the gunmen were seen shooting, or firing their guns. And therefore, this casing must have come from one of the guns found outside the club. And therefore, even if one excludes Higgs's evidence that he did tests, let's say one just knocked that piece of evidence out, one is still left with an overwhelming case against Stubbs, because we know that, and no one disputed, that the size of the casing matched the gun. It might be said, ooh, how do we know that that didn't come from someone else's gun? Which the answer is, well, the chances of that are virtually nil. I suppose it might just have been one of the other accused, but my lords, one is getting into the realms of fantasy if one says that could have been someone else's gun. Second, Evans, and I do submit this, Evans could have cross-examined Thompson as easily, just as easily, on his opinion that the .45 auto bullet and the .45 gun were of the same size and make, that they were at least capable, that one was at least capable of being shot from the other. Thirdly, if there was prejudice, it was always open to the defence to inspect Higgs's entire file, which Thompson brought along with him to court, but they didn't take the opportunity to do so, either before or afterwards. I do therefore submit it's not open to them to say there was some relevant material which Higgs would have had, so to speak, in his records, which they couldn't get from Thompson. Thompson comes with the records. And my lords, it's important to bear in mind this trial is now taking place 14 years after the event. The reality is all you really needed to see from Higgs was his records. He wasn't going to be able to remember very much apart from that. My lords, the reference to Higgs's file is at volume 6, 2331 to 2332. Fourth, as I've mentioned, it was always open to the defence to ask to carry out their own tests on the gun and own tests on the gun to alleviate any potential prejudice they say they would have suffered, but they never asked, either in the course of the trial nor indeed beforehand. And that was always there for them to examine. And fifthly, my lords, we make this point in our case, Mr. Ducil was able to ask a lot of questions of Thompson to establish the limitations of Higgs's report. And we summarise the various passages at paragraph 65 of our written case, at page 3834. For instance, there were photographs of the test bullets. There were no photographs and things like that. So the defence was able to say, well, it's not a very full report, which comes down to. Well, my lords, they were in just as good a position, if not better, getting that out of Thompson as they would have been from Higgs. And my lords, finally, and I do submit it's important, neither Mr. Stubbs nor Mr. Evans, so far as it matters for the moment, has actually identified any real prejudice, which has followed from being required to ask Thompson questions as opposed to Higgs. And I do respectfully submit this rather important point. Theoretically, I suppose, they might have wanted to put to Mr. Higgs, come on, you're making it up when you say you did a test. And then Higgs would blush and say, yes, you've got me there. But I mean, that's a fantastic notion. But this is important when one's talking about prejudice. What is the real prejudice? And it is important to identify prejudice, and I submit none has actually been identified. No real prejudice. My lords, can I just give you the references where Thompson introduces the relevant parts of, or says things about Higgs's report, and it's in his examination in chief. He reads his report into evidence at volume 6 at 2239. He identifies the .45 pistol as a .45 Lana at volume 6, 2241, line 25 to 32. And he says for that you will need a .45 caliber bullet. He says that at 2241 to 2245. He identifies the other pistol as a .357 at volume 6, 2245, line 22. He identifies KR1 as a .45 auto-fired cartridge casing at 6:22:47 to 22:48. And he explains how the .357 casing will come out of the .357 Magnum at 6:22:49. And then he goes on to explain there'll be unique markings on the cartridge cases for each of the .45 and .357 guns at 22:54 to 22:55. So, my lords, that's what I say about the admission of Higgs's evidence. First of all, the judge was quite right, given the nature of the propositions put to him, and the law. And secondly, anyway, no material prejudice has resulted. As far as the summing up goes, my lords, I accept that the judge did not give a summing up to the effect that, as you haven't heard Mr. Higgs cross-examined, you should treat that report as effectively a document which you haven't had the opportunity of hearing from Mr. Higgs on. He gives a general direction on expert evidence at volume 2, 574, lines 9 to 25, but it's a general direction. I accept, therefore, that the judge doesn't give a direction that Higgs's report itself was untested. But on the other hand, the jury know perfectly well that Thompson has been cross-examined uphill and down Dale for some time, I might add, and so they'll have all those points in mind. I do respectfully submit, however, that the fundamental point, which is that the points I've made, there was virtually nothing that could be said in any event on behalf of the defence. That's the same matching of type of, the matching of the size to the gun. There was very little to say on that. And the defence would run into the same problem, because if the judge were to say, well, I must direct you, for instance, that Mr. Higgs wasn't here to be cross-examined on the tests, then he would obviously be entitled to say, but nonetheless, members of the jury, you might like to bear in mind there was no challenge to the fact this was a .45 casing and there was a .45 gun, and likewise with the Magnum. My lords, one final point is, after the judge had finished his directions, there was quite a big debate between the defence counsel and the judge about further directions he ought to give. And that's at volume 2, page 618 to 642. But there was no request that the judge give some sort of direction in relation to Higgs and Thompson. My lords, dealing then with the question of the proviso on Stubbs, generally I submit, even if there was some error, either in admitting Campbell's evidence or Scott's evidence, or in the summing up relating to the identification evidence, or in relation to the report being admitted or the summing up on the report, I respect this was an overwhelming case. First, and most importantly, it's important to bear in mind that Stubbs was actually at the scene on any footing. No one disputes that. The question was simply, was he one of the shooters? Second, you have two independent witnesses, independent of each other. That's Scott and Campbell. Whatever reservations one might have about each of their evidence, the fact is two people independently have come up with the same notion. That is, Stubbs was one of the attackers, one of the shooters. Thirdly, you've got the evidence of two police officers, Duncan and Ryan, that they chased, well, they saw him rather, put the .45 auto under the red Honda. And then you've got the matching of the size of the casings to the size of the gun, the type of the gun, on any foot. I submit when you add all that up, really this is an overwhelming case, and if there's something wrong that's happened in the trial, it hasn't resulted in a substantial miscarriage of justice. So that would be an appropriate case for the proviso. My lords, I should say we don't have the proviso in at the statute, but it is actually set out in Bain. It's the proviso is set out in Bain. We haven't got it in the book. I apologise for that, but it's set out in Bain. I can't remember precisely where, but it's certainly there.
Well, it's pretty well known anyway, isn't it, Mr. Hall?
It's practically always exactly the same wording. Yeah. That I think I'll deal with sentence briefly in a minute, because I'll deal with both Davis and Stubbs at the same time in the sentence. If I can deal now with Davis, the first point Davis takes is that a particular complaint about Scott's deposition going in, which is the cross-examination at the preliminary inquiry, where where Davis himself, acting in person, put it to Scott that there'd been a scuffle between the two of them when Scott landed up punching him, and Scott agreed with that. And that's at 2582 to 583. That goes in. I submit that on its own. It's very difficult to see why the judge should have left that out. That, after all, was part of Davis's case at the preliminary inquiry, and indeed it provided a motive, certainly according to Davis at the preliminary inquiry, for Scott to falsify his evidence. So there was no reason at all for the judge to leave that out. The other bit of evidence that got in from the preliminary inquiry was the re-examination of Scott, when the prosecution asked him what was Davis doing? What was Davis doing in that prison? Basically, Scott then says, well, he'd been arrested for, I think, making threats to kill his girlfriend. Now, well, I accept that was obviously is prejudicial evidence. I can't gainsay that is not something which is not easy, and I accept it's not easy to see why it's so relevant, except as part of the other bit of evidence. However, my lord, I do respectfully submit that one has to look at the position from the judge's perspective, because when it's put to him that there should be some excision of Scott's deposition, it's put in the most, what I might call, sort of well, not even half-hearted. I mean, it's one of those submissions you make when you're sort of saying, I don't really mean it, but consider this. And my lord, I think Mr. Davis, Mr. Thomas took you to that. It's in volume 1, line 92, volume 1, page 92, 14 to 20, Well, Mr. Cargill simply effectively says, well, my lord, there's also this, which can I ask you to look at this? No submission at all is made. And then that's at a fairly early stage, the voir dire in relation to Mr. Scott. No reasons are given for excluding. And I do respectfully submit the judge can't be criticised, seriously criticised, having received such a virtual submission. My lord, the other point is, I think I'm right in saying, but I'll stand to be corrected. As I understand it, this point wasn't taken. But finally, my perhaps simplest point is, I respectfully submit this evidence, that is to say, what you might call the re-examination in the deposition, was not so prejudicial to Mr. Davis. The episode as a whole reflected badly on Scott. And the judge didn't make anything of the re-examination point in his summing up, except he didn't give any, I don't think he gave any particular warning about it. But I submit, bearing in mind in particular the strength of the case against Davis, that no prejudice has resulted from that, allowing that little bit of evidence to get in. My lords, the second point Mr. Thomas takes is the hearsay point. My lords, that is that members of, according I think it's to Duncan or maybe Scott, members of the crowd, as they gathered round after the shooting, gathered round the deceased body of shooting, basically pointed to Davis and said, he's the one. And my learned friend says, well, that evidence should not have been admitted. In my submission, that's not right. Can I just ask you briefly to look at how the evidence got in and how the judge exercised his discretion? And it's at volume 4. (1432). Line 25. The prosecution lay the ground for admitting, I think this is in the case of Duncan, they lay the ground from this point, 1432 to 1434, they lay the ground for admitting this evidence after Mr. Cargill's objected. You can see Mr. Cargill objecting at line 6 on 1432. And then the court says, I want more of a foundation for this evidence to go in. You see that at 1432. And then the foundation is given as to where the respective people were standing and so forth, up to page 1434, line 31. And the final bit, the crucial bit, is you can see line 22 on 1434 by Miss Kelly, that's the prosecutor. Did just one person say this? Answer no. Like I said, it was like 4 or 5 persons, maybe there, but the sound was, Mr. Cargill, I renew my objection, indicates highly prejudicial. Court, I'm going to allow it. Miss Kelly, now did Andrew Davis say anything? Reply, no. What happened next? And then the conversation continues. The judge then exercises, so in other words, the judge allows the questions to carry on. And in my submission, he was perfectly entitled to do that. And the governing law is not the common law on this, but section 39(2) of the, I think it's of the Evidence Act, which, my lord, is in volume 1 of the authorities. Tab, I think I'm right in saying 6 or 5, tab 5, that's page 4023, 4023. And you can see there's these are specific provisions introduced as exceptions to the hearsay rule. This Act having been originally passed, you can see this from 4021 in 1996. So in my submission, there's no reason to suppose it's merely seeking, so to speak, to replicate the common law. This is obviously designed as a codification of what the legislator wants. So it's 4023, section 39, subject to subsection 2 and to this Act, hearsay evidence shall not be admitted in evidence. And then 2, hearsay evidence may be admitted. And then you can see a series of specific exceptions are given. For instance, B, where the knowledge, intention, motive, state or feeling of mind, state of body of any person is a fact and issue, and the statement proves or disproves the said knowledge, intention. And of course, that wouldn't necessarily be a conventional hearsay ground for the admission thereof. Obviously, C is normal common law, but D, where the statement was made in the presence and in the hearing of the person against whom the evidence is tendered, and where such person had an opportunity of replying to such statement. My lords, that's it. That is the law. There is no need, as my learned friend Mr. Thomas says, to go any further, as the case of Collins suggested. There's no need, so to speak, for there to be any, what you might call, adoption by the accused of the statement. So in my, and certainly not when the parties are on equal footing. So in my submission, the short answer to my learned friend's submissions, founded on the common law, is that this is a different provision, and the judge was therefore perfectly entitled to rely on it in admitting the evidence. My lords, can I just mention this? The case of Collins, it doesn't in any event support my learned friend's proposition that the evidence should have been excluded. I can deal with it, I hope, briefly without going to the case. The case is at volume 2, tab 24, page 4402. And this considered the case of a statement made, I think, by a co-accused, and whether or not the appellant, in saying nothing, could be said to have adopted it as his own statement. But what is interesting, my lords, is that the case in terms notes that there appear to be 2 lines of authority in the common law. One goes back to Christie and Lechinsky, I think, which basically says that you shouldn't allow in, you don't draw an inference necessarily from the fact that someone hasn't responded to an accusation. And another line of authority from Lord Diplock in a couple of Privy Council cases in Hall and Park, and that is, they're referred to at page 4402. And in particular, Lord Diplock, the way Lord Diplock makes the point, is that if the parties are on even terms, and there's no rebuttal, that's the phrase, if the parties are on even terms, and there's no rebuttal, then the fact there is no rebuttal, the fact that there's silence, is some evidence that the person who, some evidence that the accused accepts the truth of what he's saying. Now, my lords, later in Collins, the court goes on to say, on the facts of that case, there was the silence could not be taken to amount to an acceptance of what was being said. But my lords, I submit, A, that's on the facts of that case. B, even at common law, it's recognised, at least by one stream of authority, that not saying something you might be expected to can amount to some sort of acceptance, or evidence of acceptance. But then C, most importantly, I say the common law doesn't apply. Section 39(2) is a provision, a self-standing provision, and therefore you shouldn't, so to speak, go back to the common law to try to interpret it. My lords, dealing therefore with Davis on the proviso, I again say, even if there's been some error in this case, this is an overwhelming case. There were 2 eyewitnesses who, again, no reason to suppose they put their heads together, and that is Scott and Campbell, who both unequivocally identified him. And there was no doubt that, as I recall, I think I'm right in saying, that Scott knew Davis. That wasn't disputed. And there's no doubt that Campbell picked out Davis as man at number 10, I think, at the identification parade. There's also no doubt that Davis was there and indeed in the crowd. And his defence really was simply this, supported, it's fair to say, by the transcript of Miss Colebrook, that basically I think I'm wrong about Miss Colebrook, but he was simply in the crowd, but he wasn't one of the attackers, he'd just gone back. Well, my lords, the judge put all that perfectly fairly to the jury, and I submit there's no real risk of a substantial miscarriage of justice by virtue of anything that went wrong. As I say, nothing went wrong, but if it did. My lords, that leaves me with the sentence, which basically the same point applies to both both Stubbs and Davis. My Lords, I think there is common ground between us as to how to interpret the Court of Appeal's order as to remission and so on and so forth. There's a 45-year sentence, essentially, and therefore remission for good behaviour after 15 years. But you have to take into account the various gaps in which they've not been in prison. But we put in a reply note, and as I understand it, there's no difference between Mr. Fitzgerald and Mr. Thomas and myself on that. My Lords, the Court of Appeal's judgment, as I understand it, the point that's taken against us is this. Look, there has been found to have been a breach of Stubbs's and Davis's constitutional rights by virtue of the delay in this matter being finalised, the trial coming on to trial finally. And my Lords, I accept that because there's been a decision in a constitutional motion to that effect. So that's right, it is right. So therefore I accept this is a case where there was a breach of constitutional rights. I accept too that this is a case that Mr. Fitzgerald, on behalf of Stubbs, and I take it Davis too, argued that this should be reflected in the sentence. I accept that. The question, and I accept too, that the Court of Appeal do not say in terms, by the way, what we're going to do is we would have come up with 45 years on its own, but bearing in mind the breach of constitutional rights, we're going to reduce it, let's say, to 40 years. I accept. You don't see that line of reasoning. And really the question is, therefore, when you look at the Court of Appeal's judgment, is one entitled to say that they took this point into account or not? And in my submission, you should assume that they did take this point into account. And can I just take you briefly to the relevant passages of their judgment? It's in volume 9. At page 3404. I think. My Lords, they turn their minds to the question of sentence at 3404, paragraph 216, and they talk about or rather they say that the life sentences which they were currently under were unconstitutional. That's at 216 to 218. They then discuss the judge's reasoning for imposing a life sentence, and they also go on to discuss one or two authorities. And they say, paragraph 223, they recite an authority from the Bahamas, which says, what's the right thing to do? And they say, you consider the appropriate sentence. The appropriate starting point is the sentence of life imprisonment, but there have been all sorts of other possibilities. And in Beckford, the judge in Beckford imposed a sentence of life after due consideration of many relevant factors. Trial judge didn't take that approach in this case. On the face of the ruling, he determines that the death penalty wasn't appropriate and didn't set out any factors which brought him to the conclusion that the life sentence was appropriate and why the guidance set out in Jones wasn't appropriate. We are satisfied that this is an appropriate case in which the court interfered. The sentence should have been for a specified period of time. And then they discuss various cases, or rather refer to certain cases, and say we're of the view that life sentences should be quashed. So, my Lords, what we don't know is whether or not they've taken into account Mr. Fitzgerald's point about the constitutional breach. But I submit, my Lords, two things. First of all, you should assume that they did do so. After all, they are turned mind specifically to this point. And the second point I would make is this. In one sense, it's unfortunate that the board should be being asked to decide this point. If there were any doubt on it, the right thing to do would be to go back to the Court of Appeal and say, by the way, could you clarify your judgment? Is this intended to reflect or not that there was a constitutional breach? Because you haven't expressly dealt with it. And so, my Lords, that's what I say. I say either assume the Court of Appeal have got the point. Alternatively, the right way of dealing with it, and it would be now, would be for this matter to be raised with the Court of Appeal. My Lord.
Is it permissible to infer that a constitutional right such as this has been offended in assessing the sentence? It seems likely said to be quite a bold submission that one should assume against the defendant that has been done.
Well, my lord, I don't think I can take it any further. My lords, I accept the point hasn't been adverted to. You have my submission that you must assume that the Court of Appeal must have had it in mind. But my lord, I'm not aware of any authority that says you should do that.
Lord Burrows.
The argument, I think the submission from the other side was that there were two constitutional rights infringed, or rather two different aspects. One was the delay, and the other was the time spent believing that there was a death penalty, what might call it the time on death row. Are you accepting both of those as correct submissions?
I think, my lord, I would accept in relation to delay, because there's been as I recall it, there has been a finding that the delay was of itself a breach of the constitutional rights. My lords, I don't accept that the fact that a sentence has been imposed, that the death penalty was originally imposed, but then later, at a later on the subsequent hearing, that the judge, in the exercise of his discretion, imposed the sentence of life imprisonment. I don't accept that of itself amounts to a breach of the constitutional rights. My lords, I might need to be corrected on this. I think the problem arose like this. At the first trial in 2002, it was believed that the sentence of death for murder was mandatory. In 2003, the Privy Council said that's wrong. And so from that point, I think 2003, 2004. So from that point on, any sentence of death which had been imposed mandatorily was automatically liable to be set aside or reviewed, not necessarily set aside, but reviewed on the basis that it had been imposed on a mandatory basis rather than discretionary basis. So that's the history of the matter. So there would have been, let us say, a period from 2002, the trial in 2002, when the death sentence was hanging over the accused, to the date of the decision, of the Privy Council's decision, which I think I'm right in saying is 2003, 2004, when they would have been subject to that penalty. But after that, it would have been known they would have had the right to come back and have it reviewed. So, my lords, I don't accept that that would amount to a breach of their constitutional rights.
Yes.
Even if the Court of Appeal did not take into account a breach of constitutional right, do you have anything to say about the length of the sentence? Well,
my lords, as I understand it, the length of the sentence itself is not an issue. What is an issue is it has been imposed without reference to the rights. My lords, I'm not in a position to say that because the sentence was 45 years, you must draw the inference that the constitutional rights point has been taken into account. I'm not in a position to say, for instance, normally it would be 60 years. And so you can draw the inference the Court of Appeal has taken the point into account.
Right. Anything further, Mr. Knox?
My lords, I don't think so, my lords. No, that's it, my lords.
Thank you very much indeed. Mr. Fitzgerald.
Yes, my lord. Can your lordships hear me?
Yes, we can.
Oh, yes. My lords, I have put in a short note which dealt with the points up till Friday, up till Thursday evening. I hope the board has that. If not, I'll just read it out.
Right. Well, is it very long?
No. But it might be. Can I just say that I have put in a note, but I can summarise the points, and I hope it will be available to you because it's got all the references in.
Well, I'm sure if it hasn't come already, I don't think it has come to me. We did receive an email this morning, but it
would have come over lunch, my lord, because I didn't wish to put it in until then. My lords, can I take this course? Can I just summarise the points in it, and then if it does arrive to the board, it will just simply have the references in And this, of course, only deals with the oral submissions on Thursday, because I was able to make some notes over the weekend. So in relation to Campbell's evidence, Mr. Knox invited the court to consider the duty of the judge in respect of the doc identification on two alternative scenarios. And then he said, firstly, on the basis of the position as it appeared to the judge when he exercised his discretion to permit the doc identification, and then secondly, as if all facts had been known. And you may recall he did his balancing thing of all the lists. Now, what I submit firstly is, if one takes the position on the material that was before the judge when he exercised his discretion, three things I respectfully submit are clear. Firstly, the judge knew that the officer in charge of the parade had said that Campbell had not picked out Mr. Stubbs at the parade. That point was made emphatically by Mr. Ducil at least 3 times in his submissions. I can give you the references. Is at page 373, lines 1 to 3, page 373, lines 18 to 21, and page 377, lines 21 to 25. It wasn't contradicted by the prosecuting counsel, and it was obviously true. So that's the overwhelming fact. The judge knew on the submissions made to him by both parties that Campbell had said, that Mackenzie, Inspector Mackenzie, had said that Campbell did not pick Stubbs out. Secondly, when the judge exercised his discretion, he knew that Campbell had given contradictory evidence as to whether he had picked out Mr. Stubbs, who was the man at number 5. By implication, he had not picked him out at the trial in 2007. And I just give you the reference. If you look at page 383, lines 3 to 4, the judge said, but he did say in 2002 that he identified your client at the parade. Now, the judge knew that there'd been 2 earlier trials, the 2002 trial and the 2007 trial. And what he said was, well, in 2002, he said he identified your client. By implication, he knew that that was the only occasion, because what the prosecution weren't saying, and he did it in 2007, and Mr. Ducil was saying most of the time he never did it before. And the third point is the judge knew that Campbell had made the claim to have picked Mr. Stubbs out at the identification parade at the first trial, but by implication only then, i.e. not in his other statements. So we say that those materials which were available to the judge on the submissions made to him, and the submissions are set out for the board at pages 373 onwards in volume 2, were in themselves sufficient to mandate the exclusion of a doc ID. And that's on the basis that it couldn't safely be said that there'd been a prior identification. And we say that on that basis, you couldn't say that Campbell had made a prior identification if he'd been on an ID parade, and that was common ground, and he hadn't picked him out at that ID parade, then the authorities are that it's dangerous to have a doc ID in those circumstances. My lords, we've set that out in the reply, but the key cases are Holland, paragraph 62 and 84, and the case of Lawrence at paragraph 11. But we've set that out in the reply in some detail. That's to say a reply in the record. So we say on the materials that were before the judge, he should not have permitted a doc identification. If all the facts were known beyond a peradventure, then of course, in those circumstances also we say the doc ID should have been excluded, because then it would have been absolutely clear that Campbell had expressly said at the second trial that he didn't pick out Stubbs at the ID parade. And you've got that admission at 9.2 of the Statement of Facts and Issues at page 3680. And if Campbell had in fact failed to pick him out at the ID parade, then again, the doc identification should have been excluded. Now, my lords, what I do accept, so that's our submissions as to why he simply shouldn't have permitted the doc identification, which he did permit it, and it took place at, I think page 381. Then the question is, what should the judge have directed the jury? And all the cases which say that it's not necessarily inadmissible to have a doc identification, to not have a doc identification where there's been a failure to pick out at the ID parade, stress that that only leaves a fair trial if there are the most strong directions to the jury by the judge as to the dangers. And that's in Holland, paragraph 62. That was the part of the ratio of Holland at paragraph 84. In the case of Lawrence at paragraph 11. And indeed, if one looks back to cases like Tito and Petersburg, what saved the doc identification, or what could have saved it, was sufficiently strenuous directions by the judge. And it was in the absence of strong directions by the judge that the board found that there was a miscarriage of justice. But if one looks at the directions of the judge, which is our ground 2, by the time the judge came to give his directions to the jury, the judge had heard Inspector Mackenzie emphatically give evidence that Campbell did not pick out Mr. Stubbs. And I do stress this is important. The prosecution never challenged his evidence to that effect. They didn't say, oh, Mackenzie, do you think you got it all wrong? They were putting him forward as a witness of truth themselves. A police officer in charge of the ID parade, they were relying on him for the evidence that Davis had been picked out. So it's quite a tall order for my learned friend to say, well, it's all right in those circumstances, to say, well, you choose whether you believe the police officer or Campbell, who we know from my learned friend's submissions was being held on charges of rape when he met up with Mr. Davis inside, and that's in my learned friend's submissions in his case. So the notion that he was some kind of independent witness over whom the police had no power is at least open to question, given that fact referred to in my learned friend's case. So by the time the judge came to give his directions, Inspector Mackenzie had given his evidence. It hadn't been challenged by the prosecution on that. And given that, we say, firstly, the judge should have emphatically directed the jury, in the light of Mackenzie's evidence, that they couldn't rely on Campbell's claim to have picked out Mr. Stubbs at the ID parade, and he didn't do that. He just said it's a matter for you. And we say that totally fails to recognise the special status of Mackenzie and the special dangers of Campbell. Secondly, the judge should have directed them as to the dangers of relying on a doc identification where there had been a failure to pick out the accused at the ID parade. That was the point my Lord Hamlin put to my learned friend, and my learned friend said, well, you would have to have said other things. Well, the important thing is he didn't make the all-important point that if you accept the evidence of Inspector Mackenzie in charge of the parade, that he didn't pick him out, then you're in a situation where a doc identification has been made by someone who failed to pick out the witness who he doc identifies when at an identification parade. And my lords, we've set that out in the reply at paragraph parts 3.4. That's the main reply in the bundle. And we say that this does lead to a miscarriage of justice, as I've respectfully submitted. If you look through those cases from Tito, Petersburg, Goldson, all those cases, if you look at Lawrence and you look at Holland, they say, okay, sometimes a dock identification that shouldn't have happened does slip through, but in those circumstances, it's vital that there be the strongest directions to the jury as to the dangers of relying on such a statement. Now, my learned friend, in his submissions to you, placed great emphasis on the second statement of Campbell, statement made on the 30th of March. And his point to the board was, well, look, when Campbell made his second statement after the ID parade, he talked about recognizing two people. And he said that the person who he saw at position number 2, who was in fact Evans, is a man I know as Di of Ridgeland Park West. Now, my own friend said, oh, well, at least he mentioned Di. And he said that he recognized him. But that just totally overlooks the point that the person who he said I recognized as Di was the person at position number 2. And the person at position number 2 was Evans. So he obviously didn't know what Di looked like. He's saying, I know Di, I recognize him. I know him from Ridgeland Park West, according to my learned friend. And I saw him on the parade. And yet the person on the parade he picks out is number 2, who is not Mr. Stubbs at all. And so we say, my learned friend really can't reasonably assert that Campbell claimed to have recognized Stubbs at the parade, since the person standing at number 5 was, the person standing at number 5 was Mr. Stubbs, and the person he picked out was at number 2 was Evans. And my learned friend built a great deal on this point about the recognition, but it founders on the fact that who was it he was looking at when he recognized him? He was looking at the person at number 2, who was in fact Evans. So then that leads on to it, my learned friend's second point, who was saying, well, this is really a recognition case, because he said that he'd seen him in the bar in Robinson Road. I think he said he'd seen him twice, first of all, and then he said, well, later on I saw him 3 to 4 times maybe, and that was many years ago, as far back as 8 years ago, possibly. We say this isn't a proper recognition case, and I referred you to Lord Brown's categorization in the case of John, which is referred to at paragraph 28 of France in my Lord Kerr's judgment, where he was saying there's a second category where it's questionable, and in the correct Fergus, the one which is at tab 29, they're saying, well, if you're just claiming to have seen the person a couple of times before, 2 or 3 times, then really it's more assimilated to an identification than to a recognition. And so it's not the case of a claim of recognition of a person well known to the witness, but someone cited briefly many years ago, and the recognition was in dispute. And in cases of disputed recognition, the Ebanks case establishes that an ID parade does serve a purpose. And that's the point. Is my learned friend kept on going on about all the point about the again, the risks of the doc ID is because it may be an honest mistake. The point about the ID parade, and this is what Ebanks shows, is that it can expose dishonest claims. And my lords, if one looks just at Ebanks, volume 2, tab 28, at 4477, one can see there, they talk about the 4477, they refer to Goldston and McClashen and Lord Hoffman's judgment there. And then they say, over the page at 4478, the function of the parade would accordingly have been not the normal one of testing the accuracy of the witness's recollection of the person identified, but to test the honesty of her assertion that she knew the accused. The same opinion was expressed by the board in Pop, a similar case of disputed identification, where Lord Roger referred to the potential advantage of an inconclusive parade to a defendant such as the appellant. So it's not just about avoiding honest mistakes, it's also to test a lying witness who claims to recognize the person. And you say, okay, well, pick him out if you recognize him. And something similar happens, as happened in this case, where he picks out the wrong person. And so we say that my learned friend's claim, oh, well, it was a sound recognition case, is exposed by what actually happened in this case. He couldn't pick out the person who he was purporting to recognize. He picked out someone else. And now the final point in this category is my learned friend said in his oral submissions that there was no challenge by Mr. Ducil to Campbell's claim to recognize Stubbs as one of the men involved in the murder on the basis of having seen him many years ago at a bar on Robinson Road. And you have the references page 370 to page 371, where he says, I saw him many years ago. Now, we've dealt with that point in our reply in the record. That's at electronic bundle page 5490. But can I just deal with it briefly like this? We say that my learned friend's reliance on the non-cross-examination betrays a misunderstanding of the position of counsel. The witness wasn't saying, Campbell was not saying, I know Stubbs and Stubbs knows I know him. We're well known to each other. In which case you could say, well, one would expect a cross-examination. He was asserting, I've seen him from a distance at a bar many years ago on 2 occasions. Now, if somebody says of me, I saw Fitzgerald at a bar 8 years ago on a couple of occasions, how am I going to give instructions as to whether I never talked to him, I don't know him, but I saw him in a bar a couple of occasions before? How am I going to give instructions, challenge that? How can my absence of cross-examination be a basis for saying that's an admission? You can only give instructions on that which you can be reasonably expected to know. So if somebody says, I know him well, or I recognize him and he knows I know him, but if you're just saying, well, I cited him at a bar, I didn't even talk to him, I just cited him, how can Mr. Ducil's absence of examination get my learned friend anywhere? Well, those are the points we make in relation to Campbell. We say there was a wrong admission of a doc ID, there was a failure to give proper directions. In relation to Marcy and Scott, there were 2 points that we made, key points that we made, in relation that the doc identifications which were present in the both the deposition and the trial transcript shouldn't have been admitted. And at least the judge should have edited. And we've dealt with that in our reply at 4.6. But my learned friend submitted, first of all, he said the judge was perfectly within his rights in admitting the deposition and in admitting the trial transcript, even though they contained a doc identification. And he took you to the judge's judgment, where the judge clearly was saying, I recognize that this is doc identification, these are doc identifications, but I'm going to let them in because I think there's sufficient weight to the evidence, or they're not sufficiently lacking in weight to exclude them. But what he didn't apply his mind to, and this we've set out in the reply at 4.6 at page EB 5493, is that Mr. Ducil had focused on the issue. These are doc identifications. That's why I'm objecting to them. And they should come out for that reason. And by making that point, we submit that Mr. Duseal was effectively saying, exclude them because they are doc identifications, which leads on to the point, at least exclude that part of them which contain doc identification. Can I just give you the references to the doc identification bits? I think my learned friend took my Lord Burrows to it. It's at 4.6 of our submissions. Yes, it's at page, the doc identification is at page 199 in relation to the deposition, and at page 281 in relation to the transcript. That's where he actually points and says that's him in the doc. We say that should at least be have been edited. And since he injected to the entirety of the deposition on the basis they were doc identifications, the point was clearly before the judge, and he should at least have edited. After all, Scott itself, the case of Scott in 1989, the board says you should at least examine to exclude that part which is more prejudicial than probative. And then, of course, Mr. Duseal repeated the point again in relation to the editing of the first trial transcript. And my learned friend took you to that. It's at page 255 and 256. But this is all set out in our reply at 4.6. Now, my learned friend says, well, it was too late by then to start arguing about editing the trial transcript because the doc identification had already come in the deposition. That's a complete non sequitur. The fact that there's one injustice doesn't justify compounding it by another injustice. Too late, we've already let it in relation to the deposition. So why not let it in relation to the trial as well? I mean, one, it doesn't follow, and two, by necessary implication, the objection to the entirety was an objection to that part, which involved a doc identification in both cases. So that's our response in relation to the editing point. And we say that it was a serious miscarriage of justice, not at least to edit out the doc identification. And the doc identification carries with it the injustice that the jury may think, well, since he pointed him out, that carries some weight. He actually pointed him out in court. And it has a certain dramatic effect to it. And we say at least to have edited that out would have reduced the unfairness of admitting those, both the deposition and the trial transcript. And then as to the directions, again, as my learned friend fairly accepted, it's crucial where you do admit such matters that there be directions. And again, as my learned friend fairly admitted, the direction was a direction, well, Mr. Scott was deprived of an opportunity of identifying him. And my learned friend accepted that that was not the direction that should have been given. The direction that was necessary was the defendant was deprived of an opportunity of testing whether Marcion Scott actually could recognise him or not. And I've got the note, page 5172. I think that's in relation to the Tito case. But you have the lack of a direction on the lack of an ID. That's at page 572 of the summing up. That there's an absence of a direction. There's a misdirection. That the only person who was deprived of any opportunity, according to the judge, was Marcion Scott. And we say that that was, again, with respect to the judge, a serious misdirection. Yes, it's page 572 at line 23 to 25. He was not given an opportunity to attend and see whether he was in a position to identify. And so no direction, nor was there a direction that the doc identification becomes dangerous where there's been no identification parade, and as in the absence of an identification parade, that a doc identification where there's no good reason a dock identification becomes dangerous. My lords, we've set all that out in the case, in the reply in relation to Marcin Scott at, sorry, if I can just find you the reference. It's at 4.4, page 5491. But we say my learned friend really hasn't dealt with those points in relation to the summing up in his submissions. That concludes all but the fresh evidence. On relation to the fresh evidence, I submit that the Court of Appeal itself recognised that the new evidence would have had some impact. The Court of Appeal said, well, it should have been adduced at the third trial because he was told about it. He was told about the fact that he was no longer a police officer in the second trial. But the evidence of the National Insurance Board records was not obtained until after both trials in preparation for the appeal to the Privy Council in the first time. And the evidence that was finally produced in 2018 in Bahamas when the matter was remitted by the prosecution wasn't available until 2018 when UL Johnson swore his statement. So we say, firstly, the evidence was not in fact available. And secondly, in any event, once it's accepted that it casts some doubt, or at least is of significance, then the fact that it could have been obtained earlier pales into insignificance on the question of, well, does it cast doubt on the reliability of Marcin Scott? So we maintain that point. And then finally, my lords, I turn to the point about Higgs. My learned friend accepts that at the second trial, Mr. Ducil did object. So the Court of Appeal got it wrong at paragraph 171 and saying there'd never been an objection before. That's at paragraph 171 of their judgment, page 3391. And we've dealt with the fact that Mr. Ducil did object in our reply at 6.8, which is page 3942. Now, why the evidence of Higgs was important as against Mr. Stubbs is that the evidence that the specific casings were fired from that specific gun, because when you test fired similar casings from that gun, it produced the same marks on those casings. That evidence was summed up by the judge as a crucial part of the case against Mr. Stubbs. And we say that evidence could not be tested. Now, just drawing back from it, my learned friend, Mr. Ducil, did challenge it. He challenged, can I just give you the references? He challenged it at page 1897 and 1898 and 1899 in volume 5, where he was saying, I want to test this. And again, in volume 5 at page 1908, he gave reasons. He referred to continuity. He referred to the fact that he did the examination of the article at page 1908, and he referred to the deposits on the clothing. So he did say, I want to cross-examine. He did indicate that the reason was because Higgs had done the actual tests. At page 1897, he said he did the examination of the article. And we say that's enough. If
there was never any doubt that he did the examination,
no.
That really wasn't a reason that he had to be available for cross-examination, was it?
Well, my lord, can I just put it this way? If you're going to rely on the fact that the casings match the gun. Someone's done a test and said, if you fire a bullet out of this gun, it produces exactly these markings. And that's part of the case against you. You are entitled, in our respectful submission, to challenge that. To say,
yes, of course you're entitled to challenge it, provided you've got information which permits a challenge. But why didn't Mr. Ducil make that clear to the trial judge?
Well, my lord, I can't take it any further than what your lordships have got in the. He did say, he did the examination, and well, you've got what he said.
Yes.
He says it. Just can I just give you the references? He said it at page 1897, 1898, and 1899 about he did the test, and at page 1908 about he refers to issues about continuity and the ballistics and the deposits on the clothing. So
Yeah.
he was saying I want to ask him questions, my lord. I mean, I suppose it really depends on which way round you look at it. If you start from the proposition that the prosecution have got to prove their case and the defence are entitled to cross-examine a prosecution witness to test the reliability of his conclusions, then we submit that the conclusion is it's in the interests of justice to permit that, provided the witness is available. If you start from the proposition that the defence have to justify an application to cross-examine an important witness, then I accept that.
Yes, but those are two extremes. The judge, it is argued, was entitled to exercise his discretion, and to have that discretion informed, he needed to know something about the lines of cross-examination that were going to be pursued. And it isn't enough simply to say, so Mr. Knox submits, he gives relevant evidence and I want to cross-examine him, without condescending to any detail as to what the lines were, so the judge could be alive to the significance of the absence of Mr. Higgs.
Well, my lord, I don't think it'd be right for me to try and go behind the transcript itself, because you have it there. And what I submit, and I submit as a matter of principle, is this: that where you're going to depart from the fundamental principle that the defence are entitled to question any witness, any important prosecution witness who is available, there must be some countervailing necessity. And that's the principle that one finds in the case of Davis, which is at tab 26. And Lord Carswell says at paragraph 49, there must be some countervailing necessity. And there was no countervailing necessity. So I say, when you approach section 120, you don't start from the proposition. I mean, I'm not trying to be rude. I'm just saying you don't start from the proposition that you've got to justify your right to cross-examine. You can say, this is an important witness. I want to challenge his conclusions. He's available or not unavailable. Call him, or I have a right to call him. And that, contrary to what my own friend suggests, that the Sixth Amendment is some kind of curious American departure, what Lord Bingham shows in Davis is that the Sixth Amendment grew out of a fundamental English common law principle, and that's throughout the judgment in Davis, which you have at tab 26. So, because of Sir Walter Raleigh's case, when he wasn't allowed to cross-examine the witnesses. So my lord, I think in the end it's just a question of which premise you start from. If you start from the premise, which is what really Mr. Ducil said, I have a right to cross-examine, then it's for the prosecution to justify why you shouldn't cross-examine. And that's why we respectfully submit that section 120 subsection 2 has to be interpreted as where an important prosecution witness is challenged by the defence and he's not shown to be unavailable, there's no countervailing necessity to, as it were, attenuate the right to cross-examine. My lord, I'm afraid that's as
that's fine.
That's as good as it gets. But I can't. You know, your lordships do have the transcript of what was said. But my lords, what I don't accept is that Grant justifies some departure. Throughout Grant and Davis and those cases, the fundamental principle is if you're going to restrict the right to cross-examine, you've got to have some what's described as countervailing necessity or pressing need. So if the witness is dead, or if the witness is genuinely proven to be unavailable, you have your countervailing necessity, your pressing need to restrict the right that would otherwise be unrestricted. But in this case, we say there wasn't such. Right, my lords, I accept, of course, that then my learned friend would then say, well, there was no injustice, no material prejudice. I submit that there was a prejudice because the defence were deprived of the opportunity to test whether, in fact, those casings match those in the gun. And my lord, those are the submissions I make in relation to that point.
Thank you.
My lord, as to the proviso, my learned friend's submissions as a proviso, I say every one of their witnesses that they rely on as providing this, the test has got to be, the jury would inevitably have convicted. Well, Scott, there was no proper direction to rely on him, and we say it should have been edited. Campbell, we say, was shown to be, we say, demonstrated to be totally inconsistent in his evidence. He said one thing in one trial, the exact opposite at another trial. How can you say, well, you can say the jury would inevitably have convicted on the basis of Campbell? Ryan and Duncombe, they were challenged, and the matching of the casings to the gun. Well, yes, it's true that the casings were of the nature, the generic nature that matched the gun, but the crucial evidence was, no, these casings have been fired from that particular gun, and that evidence depended on Higgs, and we submit that was should not have been admitted. Well, those are the submissions. Then, unless I can assume the sentencing point, can I just make that very shortly?
Yes.
Of course, the judge found in relation to Mr. Stubbs that he couldn't sentence on the basis of knowledge that the officers were police officers in plain clothes. He found, and so we know that the range of sentences were between 30 and 60 years. The width of that range was something commented on in the case of Bain. The Court of Appeal of Bahamas has developed principles that it's more appropriate where the death penalty is not imposed to give a fixed term sentence. And we submit that if one looks at their paragraph 228, all you can say looking at that is they refer to two cases about why you prefer fixed term rather than life sentences. Neither of those cases have got anything to do with making a discount for constitutional breaches. So whereas my learned friend fairly accepts two constitutional breaches, firstly, undue delay, I mean massive undue delay in the trial. He wasn't tried within a reasonable time, and a judicial finding to that effect by Mr. Justice Jones. And then he was wrongly sentenced to the death penalty on a mandatory basis. And that I don't think was put right until the Court of Appeal hearing in 2006. Both those constitutional breaches have historically been regarded as grounds for reducing the sentence that would otherwise be merited. And there's nothing to suggest that the Court of Appeal went through the exercise, well, X was the appropriate sentence that was merited, but for the constitutional breaches, we deduct 5 years to reflect the serious constitutional breaches, and our conclusion is Y. Or put it this way, you can't say that they said 50 years would be the appropriate sentence, but given the constitutional breaches, we've reached the decision that it should be 45 years. And when one's disposing of such vast amounts of liberty, I mean, many, many years of liberty, we do submit that there is a duty to give reasons and to address the substantive points addressed, or to show that you've considered the substantive points addressed. And we do respectfully submit, if one looks at paragraph 228, there is no evidence there that those two serious and successive breaches of constitutional rights were taken into account, or that any reduction in the sentence that would otherwise have been merited was made to reflect them. And my lord, so on that basis, I do submit that at the very least that there should be a reduction. There should be a finding that the Court of Appeal. Oh, I'm so sorry. Yes.
Mr. Fitzgerald, can you tell me, please, where we find the constitutional ruling?
Oh, yes, it's in the record. It's in volume 1 of the record. It's Mr. Justice Jones's judgment, I think, is in volume 1 of the record.
Right, I'll find it there. Thank you.
So it's Mr. Justice Jones. It's only in kind of, as it were, transcript form. Will your lordship forgive me if I just look for a moment? Oh yes, my lord, could I just track it down? But I know it is in the record in.
That's all right, Mr. Fitzgerald. I'll find it there.
I'm so sorry, my lord. Yes, we'll find that. Yes, and of course,
don't worry. You can track it down when Mr. Thomas is making his submissions, and you can tell us at the end of his submissions.
I'm very grateful. Thank you, my lord.
Yeah,
So those are my submissions.
Thank you very much. Now, Mr. Thomas.
F1.
You need a little time to change over.
No, my lord, can my lord hear me?
Yes, we can. Yes, thank you very much.
I'm just going to deal with what my learned friend said about ground 1, the Scott point first.
Yes.
I think my learned friend conceded that this is material that shouldn't have been before the court, namely the bad character evidence. I'm sorry, there's a little echo because someone's opened a door. Can you give me a moment?
Yes.
Yes, there we go. In dealing with that, my learned friend made reference to the nature of that evidence being threats to a girlfriend. I should just clarify, and the reference, I don't need to take the court to it, the reference is at electronic bundle 214 and 215. It was in fact threats of death is the way it's put, presumably threats to kill, and firearms. And so I submit that my learned friend's characterization of the nature of the prejudice is perhaps to understate it, particularly in the circumstances of the incident case. And so it follows that what I say is that this is something that shouldn't have been before the jury. It was very prejudicial, contrary to what my learned friend is saying. And the difficulties were compounded by an absence of assistance by the court, by the judge, in giving directions as to how to deal with it. And finally, on the Scott point, and I think I dealt with this in my initial submissions, but my learned friend again said he suspected the point wasn't taken. It was taken in the Court of Appeal, and again, I can give you the reference. It's electronic bundle 3312, and it's paragraph 8 of the skeleton argument in the Court of Appeal, in which this submission about the prejudicial nature of the material was made. And so that is the Scott point. And I move on from what I say is the inappropriate admission of and inappropriate treatment of bad character evidence onto the ground 2 and the hearsay point. And I move on from one area of the criminal law which requires a great deal of caution, we submit, namely bad character, onto an area of the criminal law that again requires particular caution. And we have 3 areas. We have anonymity, hearsay, and identification all rolled up in one here. And what my learned friend has said in what I say is a surprisingly broad submission is that these 3 areas of the law which require the utmost caution are all suddenly admissible as a result of the provisions in section 39 of the Evidence Act. And once again, what we say is that, as we've said throughout, is that the error made by the Court of Appeal is that when section 39(2) reads hearsay evidence may be admitted, and then it gives a list of scenarios, but what that certainly doesn't say is shall be admitted. And my learned friend's submissions were premised wholly on the basis that should be read as shall. And what we say is that it's a discretionary provision, and plainly, whilst the Act provides a gateway to adopt the language of the Criminal Justice Act 2003, a gateway for this sort of material to be admitted, to allow evidence that the common law would not otherwise allow to be evidence against a defendant to be admitted, it is a very dangerous, we respectfully submit, course. Because what is happening here is that evidence that it's anonymous, it's hearsay, and ultimately it's identification evidence of the most damning sort has been admitted. And we say that it cannot be evidence against this defendant. And I'm going to move on very briefly to Collins now. But I want to address my learned friend's principal submission, which is that ultimately section 39 stands above the common law and provides a mandatory route in for this sort of evidence. And we submit in the firmest possible terms that cannot be correct. And therefore, moving on to Collins, addressing whether this material is admissible, my learned friend is right that in the passages to which I took the court in my submissions, namely paragraphs 28 to 34, which is at electronic bundle 4401 to 4404, there is a line, and it's at paragraphs 31 to 32, where the Court of Appeal does make reference to Lord Diplock's judgment in Hall, and suggests that the case of Christie, to which I took this court to, is to be preferred because it accords with common sense. That is right, and to the extent that Hall is to be interpreted more restrictively, it is not something I'm seeking to rely on. I seek to rely on Christie. I seek to rely on the way in which Collins, the court, Lord Justice Thomas then was, interpreted the authorities in Collins. And the summary at paragraph 34 to which I referred is the court having taken into account the submissions that my learned friend was saying about Hall and had preferred Christie. And in those circumstances, at paragraph 34, it makes it plain that mere silence cannot of itself amount to an acknowledgement of the truth of an allegation. And in Collins at paragraph 36, they found there was no evidential basis to leave it to a jury even when there'd been silence. And of course, we know, my lord, in this case, that plainly there wasn't just silence. Any exploration of this evidence would have demonstrated that Scott and Campbell made it quite plain he was denying the allegations immediately. So our submissions remain as they have been, that section 39 does provide a gateway, but this is evidence that shouldn't have been admitted because it cannot be evidence against the defendant. Again, this was compounded, as it was with the bad character evidence, by a failure to assist the jury with how to deal with this evidence, despite it being summed up to them on 4 separate occasions. And we've summarised that at paragraph 14 of our written case. And so when my learned friend in his written case says that, oh well, this was all sorted out by the summing up, we respectfully differ. It was the problem was just compounded, and so where the court is left with, we say, is that some of the big red flags of criminal law, the bad character evidence, hearsay, identification, and anonymity, have all resulted in that very dangerous type of evidence being admitted when it shouldn't have been, and with the court failing to, and we say it wouldn't have been satisfactory, but failing to remedy it at all. And in those circumstances, turning to the proviso, the submission that it would have been inevitable a jury would have convicted is firstly, we say, unsustainable. If you take away the denunciation of the crowd, you take away some highly prejudicial bad character evidence, you are left with Campbell, who was subject to all of the problems which my learned friend has dealt with. And in addition, he was robustly cross-examined at 398 to 431 of the electronic case. And Scott was not present, and who the court directed the jury that they had to be cautious about. And so if that's what is left, we respectfully submit that there is no inevitability. And secondly, what we say is that to uphold a conviction where the jury have inevitably taken into account, improperly we say, both because it shouldn't have been there and because they weren't assisted, bad character evidence, anonymous evidence, hearsay evidence, and that a conviction can safely be sustained on that basis is untenable. And in those circumstances, we would ask you to allow the appeal. As to sentence, I should correct one matter, and that is we rely on the submissions about delay. But there has in fact been no constitutional court finding in relation to Mr. Davis. There was no constitutional motion from him. But we say in circumstances when the delay is identical and the issues must be the same, that doesn't in fact make any material difference. Can I assist the court any further?
Yeah, thank you very much indeed, Mr. Thomas.
All right.
Mr. Fitzgerald.
Just talk.
My lord, yes, I found it. It's page 3194.
Sorry, we're having some difficulty
Could you give me
Oh, yes, I'm so sorry, my lords. Can you hear me now? Yes, yes. In volume 8, at pages 3194 to 3195, you will see the declaration of Mr. Justice Jones that there'd been a violation of the right to be tried within a reasonable time. And there's also reference to the adverse publicity, which perhaps backs up what your lordships will have seen, that this is a very notorious case, which might well explain the pressures on witnesses to nominate the appellant Stubbs. But my lords, the most important point is that there was a finding by Mr. Justice Jones. I have found that the delay claimed by the appellant in relation to his retrial breaches Article 21B of the Constitution of the Bahamas, and he makes a declaration, but he doesn't stop the trial for that or because of the publicity. He simply gives that declaration. But obviously it would come back again as a relevant factor at the sentencing stage in our respectful submission.
Yes. Lord Jones.
The point on the mandatory death sentence.
Yes.
Trial.
My lord, after the first trial, he was, as my learned friend has fairly accepted, sentenced to the death penalty. And the first trial was culminated in 2002. Yeah. That was before the decision in Bow by the Privy Council that the mandatory death penalty was unconstitutional. And my lord, the death penalty certainly wasn't set aside until the conviction was set aside in 2006. So for the period from 2002 to 2006, he was subject to a death penalty, which in our submission would have been unconstitutional.
Thank you. And was that the case in relation to the other two defendants as they were at that time?
Yes, my lord. That would have been yes. So and your lordships have the case of Adolph Harris, which I think I took you to, being on death row for a period, unconstitutionally was taken into account by Chief Justice Conte in the court in Belize, and you also have the case, the Grenada case, which is referred to in our main case, where again the fact of being subject to unconstitutional death penalty was one of the factors taken into account.
Thank you very much.
Well, thank you all very much indeed. We'll sit again tomorrow at 10:30, and the court is now adjourned.
Yes, my lord, are myself and Mr. Thomas, are we dismissed? I mean, with honour, hopefully. I mean, with comparative honour. I mean, can we? I don't think we would have any locus in relation to the Evans case, although some of the issues overlap. But we're obviously in your lordship's hands if you want us to be in attendance.
No, I can't foresee any reason that you should be here. Mr. Knox, do you see any reason that Mr. Fitzgerald or Mr. Thomas should be required tomorrow?
No, I mean, the submission, there's quite a lot of overlap between the submissions I've made today and in relation to Evans, which I'll obviously cut to as it were, as appropriate. But
can I suggest this, that Mr. Fitzgerald and Mr. Thomas should, if possible, listen to the proceedings tomorrow, so that if anything arises that you feel would require your submissions, you can apply to us to make further submissions.
Yes, my lord, when you say listen to, you listen to contemporaneously or listen to in due course?
Well, preferably contemporaneously.
Okay, yes, my lord, yes, okay, we will. Well, I will anyway. We'll make the necessary arrangements that it's monitored.
Good, thank you very much.
Very grateful, my lord.
My lord, could I just mention one point?
Yes.
Very briefly, just an answer to Mr. Thomas's submissions. I don't submit that section 39(2) is a mandatory provision. That's say that may equals shall. That's not our case. We just say the judge was perfectly entitled to exercise his discretion the way he did. That's all.
Yeah. Thank you very much indeed. Right. See you all tomorrow.
Thank you, my lord.
Thank you.